just before lunch, I was identifying 3 pieces of evidence that I consider submission of relevance to the matters that I will then turn to the floor. I then got distracted, which is entirely my fault, from finishing those 3 by noting down the questions that my Lord Sales was asking. So if I can simply mention that the 3rd piece of evidence that I would bring to your Lordship's attention at this point is that Mr. Gard, who's the Director of Corrections at the hospital, confirmed that the medical unit in which the men were for the very large majority of their detention detained says that the unit operates as and offers the service similar to a health centre. That's at page 24. My Lord, you asked me to address 2 questions relating to the Governor-General. If I can go back through the history here, the trial judge in this case found that the default of a subsequent order from the Governor-General meant that his obligation to detain the men in a mental health institution effectively reverted to the trial judge. So what was being said was, because the Governor-General could only have detained in a mental hospital, when that order was not made, that effectively went back to the trial judge and showing what the trial judge had to order. That's at 324, paragraph 30. The Court of Appeal, when looking at that, reminded, we say correctly, that actually both powers of the judge and of the Governor-General were discretionary. Neither of them were mandatory. This is at 468 and 469. So one couldn't get back to the appellant's case that there was a mandatory requirement for a mental hospital via the Governor-General having a power to make that order. So that was the way that the question of the need for, or the importance of the Governor-General having a power to exercise was addressed below. It's never been part of the appellant's case, and you can see from the Statement of Facts and Issues at 556 that a failure to refer to the Governor-General and effectively to get an order from the Governor-General is a separate breach, but for a term, rendering the detention of these appellants unlawful. If, of course, it wasn't previously unlawful. Their case has always been that the detention of these men in the prison was unlawful from the outset and would never have been lawful in a prison, and that's at paragraph 34 of their written case at 572. So the case hasn't been put on the basis of there being any separate breach, if you like, from the fact that there was no evidence that the court did refer the matter to the Governor-General, and there was no evidence that the Governor-General ever made a separate order. So I say that really, that's effectively how the matter has been dealt with so far.
But the Court of Appeals, well, insofar as it does treat the Governor-General as having a general discretion, that seems to be wrong, doesn't it? Because of the structured nature of section 1021 sub 2 on page 629. I mean, that imposes a duty, unless the Governor-General exercises a discretion, and no one's suggesting he has. So you're left with a duty then.
I had to move everything around because I wasn't picked up.
So it's page 629, it's section 1021(2) of the Criminal Code.
Yes, but it was mandatory by reference to 1021. I can't say that shall direct is anything other than shall direct. But no, that this 1021.1 and 1021.2, both in my submission, provide the maximum amount of discretion for the judge who has just heard the case that's been put forward on fitness to plead, and then, to the extent that he's then called upon, the Governor-General. And that's really what
So how do you explain the words in 1021.2, the Governor-General shall order?
I appreciate it. I can't say that it means anything other than shall, but that's upon the point of it being reported by the judge. And what it doesn't mean in my submission is that the expectation that the Governor-General will become involved at some point, the failure for that to happen invalidates that which the judge has had to do under 1021.1.
So if the judge makes an order that is supposed to be just for a few days, and on that basis thinks it's appropriate that the person can stay in prison for a few days, doesn't report the finding to the Governor-General, so the Governor-General doesn't do anything, it's fine that they can languish there for years. That's the effect of the order, as far as you're concerned.
Well,
that's before we even get to the fact that the judge has a specific duty to send the person to a mental hospital, but we'll be coming to that.
Someone who is detained under 1021.1 because the jury have found that he's unfit to plead couldn't, we would say, be lawfully released simply because a few weeks later no separate order had come from the Governor-General or no alternative order had come from
No, but we're not dealing with release, we're dealing with the alternatives of detaining the person in a prison or in a mental hospital. And I take you to be saying that the judge has a discretion under 1021, if we ignore for the moment the Mental Hospitals Act, to detain someone in a prison until the Governor-General decides to deal with it. And if the judge doesn't report the finding to the Governor-General, so the Governor-General never does, that's lawfully how it stays until whatever period of years is then said to be arbitrary on your submission.
Well, it's going to come to an end, as the Court of Appeal concluded, if the men haven't resumed their fitness to plead. And I appreciate, obviously, there are points on review and so on, but the initial detention in a prison, in my submission, was not unlawful because it was not specified that it had to be in a prison. And one can see the sense of that in my submission, because whether someone is unfit to plead may be for a wide variety of reasons, some of which may have nothing what to do with someone's mental health. One might be unfit to plead diabetic issues, endocrinological, there might be from dementia.
I thought we were dealing with a situation where somebody's insane.
I'm sorry, I didn't...
Aren't we dealing with a situation where somebody's been found to be insane and having been charged with an offence?
Someone's unfit to plead?
Yes.
Which might have a wide variety, a very wide spectrum of why someone might be found unfit to plead.
Yes. But the predicate for this power is because they've been found unfit to plead because insane.
For these men, or generally?
Generally, that's what the provision is concerned with, unsound mind.
Which may not be for reasons that have to be dealt with in a mental health institute. And when looking at the width of the discretion that's provided for in 1021, the court may order such person to be detained in safe custody. So there may not actually need to be a detention. There may be circumstances where someone doesn't need to be detained. There may be circumstances where, although others would have to go to safe custody, these specific people that are being considered by the court don't have to. So that's the whole difficulty, we say, with the arguments that the appellant's putting forward, that the only possible place you can go to once this finding has been made of unfitness to plead is a mental health institute, because it doesn't fit in with the wording there. The court has the discretion, and then the Governor-General has the discretion, because the Governor-General shall order a person to be dealt with as a person on some mind under the laws of the state for the time being, or otherwise as he may think proper, which was exactly the point that my Lord Lord Searles identified earlier on, that the last words of that section keep the width of the discretion, which is absolutely appropriate. If you try and read into that something that says that if someone is found unfit to plead, they have to go to a mental health institution, then that takes away all of the available discretion that ought to be open to the judge who's just heard the evidence to decide what's the best place to do with this defendant, and then, to the extent that it goes to the Governor-General, to the Governor-General.
But that is based on the theory that someone has applied their mind to whether there is somewhere better than a mental hospital for the person to be detained.
Well, there's
no one has here. And just going back to the point you were making, because I understood you to be saying that on some theory that if the Governor-General, if the matter never reaches the Governor-General, his discretion bounces back to the first instance court, as to which I have to say I have reservations as a theory.
Yes, well,
but even if it did, no one at the court level has exercised that discretion. As I understand it, the court just made the initial order, and that's been allowed to drag on indefinitely since then.
Well, one couldn't, in my submission, properly read into the orders that the judge made for either of these men the fact that no thought was given where to send them.
Right, but the judge presumably was addressing matters on the basis that of the law as it stood, which called for the question of place of detention then to be passed on to the Governor-General.
Well, one can do part of your duties properly and not others.
Yes, exactly. but you seem to be making a point, I may have misunderstood, that because the Governor-General was never alerted, never exercised his discretion, that discretion somehow bounced back to the...
Oh, I'm not making that point, my Lord.
Oh.
That was what the trial judge,
Okay.
It was the trial judge who proceeded on the basis that I'm sorry, I obviously didn't make that. That's when I was trying to set out how this point about the Governor-General...
So that's not your legal...
How it had basically come through the case, that the trial judge said that if the Governor-General doesn't make the decision, then the Governor-General would have had to order detention in a mental hospital, and that bounces back to the trial judge. And the Court of Appeal said, no, that can't be right, because actually both of them had the discretion to decide where to send them. And so you can't get to the appellant's case that the only place that they could have been properly and lawfully sent was a mental hospital by reference to what did or did not happen with the Governor-General.
I see. So that's predicated on the Court of Appeal being correct in its approach to Section 1021.
Yes, that there is, and let me say there are perfectly sensible reasons for why there should be discretion, and not least of which is that either one of the judge or the Governor-General, or indeed both, might decide that no further steps are needed. Equally, of course, and this was the point that I made right at the outset, where you have someone who, in the specific position of Mr. Knoll, for example, has been regarded on a number of occasions as being unsafe to treat in a hospital, there might well be very much more of a rationale for saying, sorry, you can't go to the one mental hospital that we've got on the island, you have to go to the prison. And that is really the whole difficulty that we say there is with the argument that there was only one sensible place, or only one possible lawful place that either of these men could have been sent, and that it was mandatory that both of them be sent to a mental hospital. It doesn't fit in with the wording of the code. And one can see in my submission why the wording of the code provides this amount of discretion, because it really isn't a one-size-fits-all. It may well be that there are cases where going to a mental hospital is the obvious approach, and we know from some of the authorities in the bundle that I think it was Mr. Stevens was at least part of the time in the mental hospital, and the comment was made by the judge there, well, he could have been in either Bordelais or he could have been in the wellness centre. But but it wasn't mandatory for the judge to direct mental hospital, and it wasn't mandatory for the Governor-General to direct mental hospital. And one can't get to the point that the appellants say, which is that it was unlawful from the outset because they didn't go to the mental hospital. Now, I do need to deal with the point about implied repeal, because the appellants are looking to the Act effectively as a tool to interpretation to the code to say, well, okay, we accept that it doesn't say in terms in the code that they have to go to a mental hospital, but that's the only proper interpretation of the code, is that that's where they could have gone. The difficulty with that is, it's at page 633. If any person upon arraignment is found by the jury to be insane, the court shall order that the trial be postponed and becomes of sound mind, and in the meantime he or she be detained in custody in such mental hospital as the court appoints until Her Majesty's pleasure is known. There is no squaring of the circle between what we would accept is the mandatory language of 31.1 with the discretionary language of 1021.1. The construction of 1021.1, as what we say the later statute, gives the judge discretion. That is the only construction we say that is possible, and that comes from the O'Byrne Authority and the references at 1191. That is why, in circumstances where the Court of Appeal had specifically asked the parties to set out what their case was on implied repeal and to set out the legislative history so that they could actually address it, we say that they were right to draw on what would otherwise be this unusual route of implied repeal. The history is set out at 422 paragraph 12, and 46670 is the way that I think yes, 466 paragraph 70 is the way that the Court of Appeal were dealing with the legislative history on the basis of that which they had asked the parties expressly to provide. That Section 31 predates Section 1021.1 of the Criminal Code. And yes, there had been this element of ping-pong, it would appear. But...
So does that mean the law has changed periodically?
We don't what, sir?
Does that mean the law has changed periodically, so that sometimes it was one prevailed and sometimes the other one did?
Well, that would be a strange conclusion, wouldn't it?
Well, that was the point I was making, really.
It would be a strange conclusion. And so if one is looking at which one would have priority, then in my submission, it has to be the code. I mean, if one looks at the way that this question of implied repeal was considered in Plan Byron, 766 paragraph 67. And I appreciate that this is a dissenting judgment, but the principles that are being set out in there say are fairly apt, referring to the case over the page at 767 to B.H. and Lord Advocate, where the Supreme Court stated the presumption against implied repeal is even stronger the more weighty the enactment that is said to have been repealed. And the comment was made there, statute law in St. Lucia doesn't get much weightier than the civil code. That would apply, we would say here, that it doesn't get much weightier when you're dealing with questions of criminal procedure and what to do with people who are not fit to stand trial of the charges, the offences with which they have been charged, than the criminal code.
Why is that intrinsically weightier than legislation dealing with how people who are insane should be treated?
I'm sorry?
Why is it somehow intrinsically weightier, the civil the code, than other legislation? I haven't understood that.
Well, it is, when one looks, as I've identified, albeit briefly, the scenario that is potentially facing a judge who has just had a jury find that someone is unfit to plead, then the rationale is, in my submission, far stronger for there to be discretion for the judge to decide what to do with the person in front of him than only being entitled to send them to a mental hospital. And we can see the difficulties. We're looking at this at principles, not the specific facts of these men's case, but Mr. Knoll exemplifies the difficulties that there would be in saying that the only place that he could ever lawfully have been detained is a prison where treating doctors have said, is a mental hospital, where treating doctors have said, we will not treat you there.
But the Governor-General has power to designate part of a prison as a mental hospital. Under Section 30, I think. So that could have been got round in that way.
And that argument was run in the Court of Appeal, and the Court of Appeal said, well, look, that doesn't help the Attorney General because there isn't any evidence that ever.
Well, that's true, but it answers your point, which means that it's perfectly workable. Perfectly workable to apply Section 31, because if the only place in practice is a prison, and it said, well, somebody needs, it's absolutely essential in his case that he gets his treatment there, then part of the prison can be designated as a mental hospital.
Sorry. It's like having subtitles. I just need to make sure that I'm understanding what's being said.
Absolutely.
No, well, that isn't. We haven't attempted to go further than we haven't attempted to cross-appeal that part of the decision of the Court of Appeal that Section 30 didn't assist the state. I'm not suggesting that it does assist the state.
No, but you were making a submission that I thought that there has to be discretion because it may simply be that the only place which is possible in reality to safely detain an individual is part of a prison.
Yeah.
And why isn't it an answer to that to say that in that situation there's a recourse which is to designate part of the prison as a mental hospital so that you don't break the law by not complying with Section 31?
Well, because it doesn't just, I'm saying that the breadth of discretion doesn't just go in the direction of, well, you might need to be imprisoned, or you might need to have the surroundings of a prison around you to keep everybody, including yourself, safe. It might also go to the point that actually nothing needs to be done with you. And that is a discretion which is possible on the wording of 1021(1), but it's not possible on the wording of Section 31. But it ought to be, because the person who has just heard the case on unfitness to plead has got all the maximum amount of information as to what should properly be done with that individual at that point in time.
Well, it might be a different argument if you were here trying to justify the fact that these people have been released and it was being said against you there was no power to do that because they were obliged to be sent to the mental hospital.
But
that's not what it doesn't follow from that because you might have been able to release them, therefore it means you can imprison them without in custody as if they've been convicted.
No, well, the point of construction of 1021 should apply really irrespective of the facts of the person that is saying one way or the other they were badly done by. Yes, it might be different facts, it would give me different arguments, but the point we say is the relevant one, is that there is a discretion under 1021(1). There is not, on the face of it, a discretion under Section 31, at least for the trial judge. There is a massive discretion for the Governor-General under both the Code and the Act. But the contention, if the only way that one can look at these is that one is discretionary and one is mandatory, then in those circumstances, that's exactly why the Court of Appeal were correct to say they can't coexist.
Well, why can't you simply read the discretion is limited by Section 31 so that the place where and that the court thinks fit has to be one that complies with Section 31?
Well, one is a discretion to do what you think is fit on the facts that you've just overseen, and the other one is you don't have any discretion at all. It is completely mandatory, and it has to be to go to a mental hospital. And those cannot be, we say, reconciled.
Well, at the moment, I don't see why not. It seems perfectly possible to say you have a discretion, but it's subject to. But you also must send them to a mental hospital, so that limits the discretion, but it's not, doesn't make Section 1021 inoperable.
With respect, my lord, there's no discretion provided to the judge who's just overseen the failure to plead trial at all if the only thing he can do following the jury saying unfit to plead is say off to the mental hospital with you. There's no...
Well, if there's only one hospital, then in practice there isn't.
He's either got possibilities or he's got one route. And if he's only got one route via one enactment and he's got multiple possibilities as seems fit to him under others, that's when you can't square the circle, which is when the issue of the implied repeal comes in. Now, our case, of course, is that there is a marked distinction between what is provided under 1021 and what is provided under Section 31, only insofar as it relates to the order that is open to the court to make immediately following the trial. The discretion for the Governor-General, to the extent that one gets to that point, would have been one that would have been open under whichever one. So the provisions of the terms of the doctrine of implied repeal would only bite in respect of that one small bit of Section 31, where instead of providing that shall detain in a mental hospital, it goes back to the wider terminology of 1021(1). But I don't think that's a point that I can really labour an awful lot further, my lord. So you say that the other provisions of St. Lucian law that the appellants rely upon as saying, well, this is why mental hospital was mandatory, don't in fact, in these circumstances, assist. The appellants do additionally rely on the wider jurisprudence, Strasbourg jurisprudence, to support the contention that those found unfit to plead must be sent to a mental hospital. I think it has been accepted in writing that there is no authority, even from Strasbourg, that suggests that detention in a mental health institution is mandatory. I'm conscious of the time. Ashingdane, page 679, accepts the principle that there needs to be a connection between the purpose of the detention and the place of the detention. Ruman, the relevant part of which is cited at page 1452 as part of the Strasmere judgment, but is also set out separately in the supplemental bundle at 57 and 58, does reiterate as a point of, well, we're not saying anything novel here, that there isn't a blanket rule that the only place where somebody who is mentally ill can be detained is in a mental hospital. And the emphasis, and we say the Court of Appeal was right to reiterate, as they did at 470, that the European jurisprudence is so fact-specific, it's addressing in the evidence that's put forward in the individual cases of the detention and its suitability to the conditions that the applicant in each case has demonstrated. It's very difficult, we say, to assist this court in construing the code in anything other as supporting the argument that there is a discretion. So up until the point that both appellants' detention became arbitrary, then in place of their detention, we say, started out being lawful in prison with the, I appreciate there is no evidence up until the point of the transfer to Bordelais, but certainly from the point that they were transferred to Bordelais, with the care and the treatment that we can see documented through the record of proceedings, up until the point that their continued detention served no purpose because there was not going to be any fair trial come what may. Now, one then comes on to, well, if we're wrong about that, what would be the upshot? Well, would the detention in the wrong place make their detention unlawful? And would that be a breach of any of their constitutional rights? Is the location of their detention essentially critical to the legality of their detention at all? And I draw support in that regard from 1228 Lumber and paragraph 68 and Kambadzi at 973. Obviously, I will, if I have time, I will come back in more detail to both those judgments in the context of reviews, because both of them are far more relevant to the question of reviews. But the principle of when a failure to take a procedural step, which is effectively what it is, deciding on the where and the how of someone's detention, once the order for the detention is accepted as being lawful, undermines the whole validity of the detention, is of more general application.
This detention, the problem with this detention is that it wasn't made in accordance with the law. That's the fundamental issue. It's not, the
lack of reviews
simply about
was not in accordance with the law. But if one is, and I appreciate that I'm facing something of an uphill struggle here, my lord, but if one accepts that the decision where to place the men was a matter of discretion, and one notes that it was never any part of the appellant's case that the discretion ought to have been exercised in favour of a mental hospital, then no, we would not accept that detaining the men in prison was contrary to the law. Because there's no mandatory requirement under the laws in St. Lucia that the only place they could have been detained was in a hospital. And one can't get any additional support from, for example, Strasbourg jurisprudence to show that the only place that someone who's mentally unwell can be detained is in a hospital. Now, I do accept, of course, that it does come to an extent to whether it was mandatory or whether it wasn't. But if there was a discretion that was entrusted to the judge, and at the point that it transferred over to the executive, the Governor-General, to decide what to do with any defendant who's been found unfit to plead, then it doesn't follow that the detention of these men was unlawful. And you say, that's not the way in which it was put. It's been put all the way through that it's mandatory mental hospital, mandatory mental hospital. What was I saying? Oh yes, I mean, reference to Kambadzi. One of the ways that the question of the lawfulness of the detention can be looked at in my submission, some useful assistance from Kambadzi at 990. The way that Lord Kerr was approaching obviously a different situation where there was the question of the reviews and when the reviews hadn't been carried out. But what he was saying was it's about whether there is an adequate connection between compliance with the duty and the lawfulness of the detention. And if one approaches this on the basis that there is a discretion to decide where to detain them, then the fact that they went to a prison means that there simply isn't a connection between the duty to detain them and the lawfulness of that detention. The location of where they had to be detained simply isn't relevant to that. Now, in the context of whether there is a breach of either of the appellant's constitutional rights because they were detained in a prison, As a reminder, the trial judge found that the fact that they were in prison was a breach of their right to liberty. The trial judge found that the fact that they were in a prison was inhuman and degrading. He did not find that there was a wider breach of the right to protection of the law, and that wasn't cross-appealed. And then the Court of Appeal did find, in addition to setting aside the other declarations, that once the detention was arbitrary, there was a breach of the right to protection of law. So those were the constitutional rights that were found and then set aside and then found again below. The Constitution expressly provides for the appellant's deprivation of liberty where it's authorised by law for those who were unfit to plead, as they were. The starting point in our submission is not once that finding had been made by the jury that they were entitled to freedom. The starting point is that the deprivation of their liberty whilst they are unfit to plead is justified. The Court of Appeal accepted, of course, the constraint that that is only up to the point that their detention becomes arbitrary, because the purpose for which they are being detained, to see whether they can regain their fitness to plead and answer the charges, can no longer be carried out. But the question of whether there is a breach of their right to liberty has to start on the basis of our submission that you don't have it if you've been found that you are unfit to stand your trial. The appellants are saying that the where of their detention, the location of their detention, can affect this without any consideration of the basis on which they have been deprived of their right to their right to liberty. And that, in our submission, cannot be right. CPSAD, or the second CPSAD, the alternative CPSAD, which is at the back of the bundle, is of assistance here. This starts at 1356. Now, this was, okay, so a couple of, oh, yes, several of you. Claimant's sister and her brother were 16 and 13, charged with murder, and so they were under 18, and they were put into adult prisons, effectively. They were, let's see, 1381.
Sorry, page again, please. Page again, please.
1381, apparently.
1381, yes, sorry.
Thank you.
Now, this is the judgment of Sir Bland McCloskey. And you can see, my lords, that consideration is obviously given all the way through the judgment to the fact that these are children, that there are specific international standards, specific requirements as far as children are concerned, because whether one is a child is essentially binary. You're either over 18 or you're under 18, which is obviously not the situation where you've got someone that's been found unfit to plead, that may be for a wide variety of reasons and with a wide variety of outcomes. It starts at the bottom of 1381. Was Section 4B, as the Trinidad case, so we're dealing with the provisions of the Trinidadian Constitution. The Board considers in any case where the court is required to determine when there's been a breach of the protection of law clause, it's necessary first to identify and then evaluate all material facts and considerations. Material in this context denotes those matters that have a bearing on the question of whether the right protected has been breached, fact-sensitive and case-specific. The second relevant aspect of the law, procedural in nature, paragraph 64, is the law which provides for recourse to the High Court in joint judicial review and constitutional challenge, not something that comes into play here. And then 65, the Board drawing together the material facts and considerations, mandatory terms to provide persons such as the appellants, who of course were under 18, with substantive benefits and protections. Those statutory provisions failed the appellants as they were impotent throughout the periods under scrutiny. Second, this had a single cause, the failure of the executive to ensure at the time that the bringing provisions into operation that the requisite detention facilities were in place, because there wasn't anywhere where they could have been detained that was suitable for them under 18. Third, that was in clear defiance of what Parliament had laid down. And fourth, one major consequence was that they were, the Chief Magistrate made successive remand orders which were unlawful, unquestionable gravity. Next, paragraph 69, relevant to consider whether the executive offered any defence or justification. There was none. Conduct of the executive was incompatible with international law provisions and standards. And then finally, necessary to consider paragraph 71 at 1383, the impact of the executive's conduct on the two children concerned. This had both legal and factual elements, that the conduct was an interference with their liberty. It's no suggestion the deprivation of their liberty was inevitable by reason of the Bail Act, as the legislature had prescribed how the deprivation of their liberty was to operate. Pausing there, that is not the case, we say here, because the legislature had not provided how the deprivation of liberty for those who are mentally ill should operate. They provided a discretion. Furthermore, although the fact that they would have been detained in any event is a relevant factor, the right to be detained in a designated place with particular environment, culture, conditions and facilities is an aspect of the fundamental right to liberty which the Constitution of Trinidad and Tobago protects. And we're not suggesting that there's any sensible reason to try and interpret the Constitution of St. Lucia in any different way. What there does have to, and the way that this is approached in the need to identify and then evaluate the material facts and considerations, including, of course, impact and the fact that they would have been detained in any event, is something that applies just as much, we say, to the contention by the appellants that there was a breach of their constitutional rights as far as their detention in prison was concerned, because they would have been detained in any event. If
that goes to damages, that point, doesn't it?
I'm sorry?
This goes to damages, this point.
This goes... No, it doesn't. No, absolutely not. This goes to the finding of whether there is a breach. It'll certainly go to damages as well, but it goes primarily to what was the right and was there a breach of it. And this is why, effectively, when one's looking at whether there's a breach of the constitutional rights, we're not simply in the Lumber-Kambadzi situation of, oh, well, there's no causation, straightforward claim and tort. But when one's looking at it on the basis of whether there's a breach, then these matters that are being set out here absolutely are relevant, because they are saying there is a breach to our right to liberty because we were put into a prison. Leave aside everything else for now, but there is a breach to our right to liberty because we were in location A rather than in location B.
But it's not just the location, isn't it? You make it sound as though it's a matter of whether they were on one side of the street or the other. The point is that they were incarcerated in a place that was totally inappropriate, a place of punishment instead of a place of treatment. And that is a fundamental difference.
That's the difficulty, my lord, that there is absolutely no authority that supports the idea that detention in a prison as a blanket rule is inappropriate for people that are mentally ill. That's the difficulty. It might well be that there are some jurisdictions that would do that, but there is nothing, and if there had been, then the appellants would have identified it. There is no authority that supports such a bold statement of what their entitlement was.
Well, except in this case, both the Criminal Code and the Mental Hospital Act. The Criminal Code, when you read 103, whatever it is, 103.2, that makes it clear that the Governor-General's order is to be for treatment in accordance with mental health legislation unless he exercises discretion to otherwise, and Section 31 of the Mental Hospitals Act makes it clear that it's essentially the same position. Well,
obviously that was not accepted by the Court of Appeal, and it's not conceded here. Say that there is an option sometimes or a mental health institution, but there is not a requirement. And if and one has to look as to whether the fact that they were placed in a prison was a breach of any of their constitutional rights, not, we say, on the basis that, well, obviously they were in the wrong place. But as is being identified here, they'd have been detained in any event. The right to be detained in a designated place with a particular environment, culture, conditions, facilities is an aspect of that. And this is where the Court of Appeal were entirely right in my submission in saying, but there's no evidence. And what one can't do is simply look, as the trial judge did, to, well, generally, don't we all know that prisons are nasty places for people who are mentally unwell? And the entirety of the trial judge's consideration of this was based, not even saying, well, I can take judicial notice of the fact, but based on a sort of general assumption that everyone would accept that. And that, looking at the way that it's been identified in CPC manual, that's just not enough. That you can't find a breach of constitutional rights without some form of analysis of the environment, culture, conditions and facilities which were effectively intended to be protected. And just saying, well, it was a prison versus a mental institution, in my submission, doesn't come close to it unless the only place that is designated is a mental institution. And that, of course, was the case in CPSAD, because the only place that was designated for a child was in a specific place that was suitable for a child. And similarly, in the case, although obviously that was more of a damages case, of the young boy with Prader-Willi syndrome, I think JM, where it was specifically required to be accommodated in location A rather than location B. Now, obviously, this all does come back. My Lord Reid identifies. How do you look at this? Is there a mandatory requirement for people who are mentally ill to go to a hospital? If there is, then obviously we accept that wasn't followed, because they did go to a prison and they stayed in a prison. But if one approaches this on the basis that actually this was discretionary, one might generally expect that a mental hospital would be the location, but it isn't always going to be the case, then you do have to do more of an analysis before finding that there's breached the constitutional rights than was done at any point at first instance, certainly here.
But surely the question is more than one of location, it's a question of regime. I mean, the object of the rules here appears to be to put the matter into the hands of the Governor-General so that the detention is at his pleasure. That doesn't mean he can detain people at his will just because he feels like it. It means that he has to keep constantly under review whether it's appropriate that they remain in detention. So part of what seems to have gone wrong here, it may be said, is that by failing to pass the matter over to the Governor-General, that regime hasn't been triggered at all. He hasn't been actively keeping under review both whether someone might actually be fit to face trial, so that they can face a trial, but also whether they may require to be detained on general mental health grounds, because they're a danger to the public. None of that has happened at all.
Well, nor has that been the appellant's case. The whole aspect of the importance to the lawfulness of the detention, the place of the detention, of handing over to the Governor-General, as I identified straight out lunch, that has formed absolutely no part of the appellant's case. There has never been an argument that the Attorney-General has had to meet that goes to, because you didn't on the evidence, or at least there's no evidence to show that you did, if I can put it that way around, because there is no evidence to show that you did pass it over to the Governor-General made an order, that in and of itself invalidates the decision that the judge made ab initio, or indeed from such point as the Governor-General might reasonably be expected to make a decision. That's not something that the Attorney-General has ever had to meet. Now, obviously, I appreciate that the Privy Council, if you want to decide the basis on looking at the provisions of the code.
Putting it to you now, what do you say the answer is?
I'm sorry?
I'm putting it to you now. What do you say the answer is?
Well, we say that the importance of the Governor-General the role of the Governor-General, does not wipe out the validity of the initial order. That the initial order was valid in the place where the men were detained, and of course the lawfulness of the detention, until the Governor-General's pleasure is known. If the Governor-General's pleasure is never known, then it doesn't roll everything back and say, well, what we decided then was wrong. I do accept that there was a mandatory provision that the judge shall pass the notice on to the Governor-General, but that's not something, again, that we would say would invalidate the decision that the judge has made. Now,
what if Section 31 was not impliedly repealed? Do you accept then that their detention was unlawful, or are you, in that event, trying to make an argument that it was somehow lawful?
If Section 31 was not impliedly repealed, then I would accept that it was not complied with. But the order that was made for both, the power that the judge had for both men's case, came from the code. It didn't come from the Act. So, to the extent that one has to look to the Act, then no, put that a different way. The code stands alone. The code does not need reference to the Act to understand what it means. And the orders that the court was making for both men was pursuant to the code. If you can only, and we would say this would be not the correct approach, but if you can only construe Section 1021 by reference to the Act, because the mandatory provisions of Section 31 are somehow implied into the code, say it would be completely the wrong approach, but if that is the right approach, then I would have to accept that the mandatory provisions of Section 31 weren't adhered to by the original judge.
Well, on any view, they weren't adhered to, so what I'm asking is, if Section 31 was not impliedly repealed, does the admitted breach of Section 31 by itself render the detention of these men unlawful from the outset, or do you have some fallback argument that it was somehow lawful even if Section 31 was valid law and there was a breach of it?
We would say that the location of the detention is not sufficiently closely connected to the lawfulness of the detention that a breach of Section 31 wipes out the lawfulness, because the lawfulness of their detention comes from the finding of the jury that they were unfit to plead.
You're completely, if I may say so with respect, missing the point that's been made to you repeatedly. It's not simply a question of location. The difference between, I don't know, Pentonville and Broadmoor isn't simply that they're a number of miles apart from each other. There are different regimes, different... there are all sorts of differences between the two institutions, and being an inmate of one as compared to being an inmate of the other.
There may be, but these are men who... Mr. Knoll was in maximum security for a short period of time because he proved too difficult to manage otherwise, but the men were, for the vast majority of the time, in the medical unit. And the medical unit, according to the Director of Corrections, operated as a medical centre. That is the evidence that was available. There was evidence from the appellants about the conditions that they faced, but as my Lord Legate identified, that was the trial judge had said, well, there's no reliable evidence. So there was nothing effectively that could say, well, the conditions in which these men were held, simply by virtue of the fact that there were taller walls with I know what it looks like, tunnels with barbed wire around it, that the conditions to which these men were subject was actually, to any appreciable degree, different from that which they would have had in a mental hospital. There isn't evidence, and it would be unwise, my lord, to go down the route of assuming that because one is a hospital and one is a prison, one must be suitable and one is not.
So do I understand that we shall have to deal with a submission? We will have to address a submission that if the position is that Section 31 we find was not impliedly repealed, and if the judge fails to make an order in accordance with Section 31 and made an order in breach of it, nevertheless, that doesn't affect the legality of their detention. Is that really the submission that's being made to us? Doesn't really matter what Section 31 says, as far as lawfulness goes. I'm not going to send them to a mental hospital, even though the law says I must. Their detention will still be lawful because they could be detained somewhere, and so it's lawful, even though I'm sending them to a place that's designed for a totally different purpose.
If they can't be construed together, and the Court of Appeal held that they can't be construed together, and the approach that my lord is taking is very much that fact, they can't be construed together,
no, that's
that's precisely why it ends up in the situation with the implied repeal, because you can't have a meshing of, on the one hand, decide what you want to do, and on the other hand, you can only go down one route.
I understand your argument about implied repeal. What I'm trying to press you on is whether we have to deal with an alternative submission if there is not an implied repeal. And unless you're going to withdraw it, at the moment, I think you're making a submission that even if Section 31 was part of the law and the judge disobeyed it, you're actually inviting us to find that that did not render their detention unlawful.
Yes.
Thank you.
You do still, even in circumstances where it's mandatory, as it was in CPSAT, you do still have to do, we say, the analysis that is set out in CPSAT. It's not enough just to say it was mandatory to go to a mental health institution if that were the conclusion that your lordships were to reach. There does still have to be this specific consideration which includes the impact on the appellants, the fact that they would have been detained in any event, and some form of, and this is going to the question of the breach of the right, it's not just going to damages, my lord, and the analysis of the environment, culture, conditions of facilities. And that comes back to the point that my Lord Reid raised, that it just isn't sufficient to say there is such an appreciable difference between a prison, without knowing anything about the relevant facets of their treatment, and a mental hospital without having, and bear in mind that we've got
Well, the starting point is that they are very different sorts of places, so we can tell that from the legislation itself. There'd be no point in legislation saying you send this person to a mental hospital, you send that person to prison, unless there were significant differences between them as different types of institution. Now, if you're saying that in this particular case, one or both of these people were put up in, were detained in a psychiatric unit within the prison, for example, I've seen no such finding. I have seen a finding that Mr. Noel was housed in the maximum security unit.
He was for a short time, yes. He was Mr.
But the point is the one I've made. Yeah. So, I mean, really, you've got limited time. You're flogging the same horse, but it's up to you. But I would have thought you might want at some point to get onto the issue of damages.
I haven't dealt with the question of reviews. That has been identified to a certain extent in the written case. And it's not, we say, a question of causation. Kambadzi and Lumber were dealing with straightforward torts, no need for causation to show that if you'd done everything properly, then the same thing would have happened. It's not, we say, that's not the right approach when you're dealing with breach of constitutional rights for the reasons we've set out in CPSAT, which I've just taken your lordships, that one cannot untether the claim for breach of the constitutional rights from the realities of the mental health of these men, and the extent to which the failure to have any reviews made any difference to their ongoing detention. And that, of course, was precisely what both sides were relying on this in the Court of Appeal, which was a very similar case where the point was made, and we say quite rightly, that a review to identify whether someone has regained fitness to plead so that they can actually answer the charges that have been brought, if it goes in their favour, they don't get released. They get back into the criminal justice system to stand trial. That was the point that was made in Bissar, and Massimo is completely the one that we would urge on your lordships, because the review, whatever happened on any review at any point from the start of their detention till the end of their detention, would not have resulted in either men's liberty. What it would have done, potentially, is start the ball rolling towards pleading, standing trial, potentially being acquitted and being released, or potentially, of course, being convicted and then further detention. But there could not have been an outcome to a review of their fitness to plead at any point that would have resulted in their liberty. And that means it's not a causation point, that's a point where one has to look at the reality of what the basis on which both men had been deprived of their liberty. They had been deprived of their liberty whilst they were unfit to plead. And so it's not an answer, as the appellants have said, to say, well, they don't have to prove causation, they don't have to prove it would have made a difference. It's not about whether it would have made a difference or not, it's the fact that there was no outcome that could possibly have resulted from a review that would have seen them at liberty.
Well, I wasn't following that. I understood you at one point to be saying if there was a review, they were found fit to plead, you'd have a trial, they might be acquitted.
Yes, they might be. Yeah, so it's the start of the process, right. That there is no direct connection. And the point, I've set out the relevant provisions in the... Well,
that might have been better for them than being in prison for decades. To stand trial and potentially be acquitted and released.
Yes, and of course, from 12 years onwards anyway, then they've already been...
Even before 12 years.
Yes.
Let's say they were fit to plead after 6 months. That would be better for them if that had been picked up and they had their trial, potentially being acquitted. That would be better, wouldn't it?
It's not about whether it would have been better for them, we would say. What the appellants are saying is that the Court of Appeal was wrong in saying that there was an obligation on them, the appellants, to show that the outcome of any review would have been that they would have been at liberty. But actually, when one is looking at the basis on which they were being deprived of their liberty, which was because they were unfit to plead, then the reviews would have done no more than start the ball rolling. And so there isn't that direct connection between the reviews and their detention. They would still have been detained, whatever happened on any review. It would have given the opportunity for something different to have happened at a later point, but it would only have been an opportunity. What nobody is suggesting is that there is an obligation on them to show that they would have been acquitted at the trial. One might have thought that would, if they were fit to plead, it would have been extremely difficult to have seen how they'd been acquitted. But that's not the point. The point is that if one looks at, to the extent that Cambazi and Lumber can assist in considerations of breach of constitutional rights, then what is being said in both of those is that we've got to have this connection between the reviews in those cases and the detention. Now, with the people that were where they had to have a review to see if they could still be deported, then there was a direct connection between a review and their ongoing detention. That connection is missing in this case because the most that could have happened if there had been a review is something else could then have happened that would or possibly could at the end of the day have resulted in their liberty, but there was no outcome of any review that would have resulted in liberty.
Yes, thank you.
I'm just seeing if I appreciate my Lord would like to move on to damages, which I will do shortly, but I'm just checking that I've yeah. Obviously, if your lordships were with us on any of our submissions, then we wouldn't need to be addressing damages. However, we say with huge reluctance, because what nobody wants to do is be back here again in 3 years' time if it's been considered locally and then reviewed, etc. But if there is anything additional to that which has been found by the Court of Appeal already, then that has to go back to the local courts to consider. One can't properly default to the trial judge's assessment of the damages that would be appropriate for the breach of any of their constitutional rights, because it wasn't, in any proper sense, an assessment. There was essentially a mathematical exercise of what an appropriate daily rate was times by the number of days. There was no attempt to personalise any assessment. The Court of Appeal, of course, did. The Court of Appeal set out very, very fully the matters that were relevant to the assessment of damages. There was no consideration of what difference reviews would have made, which is relevant, as CPSAD shows, and indeed was emphasised in the EW case at 1585 and 1586, that you need to have this benchmark over when somebody would have been leased. There's no attempt at tapering. There's no consideration of any overlap. I haven't addressed, my Lord, because you've indicated you wish me to move on to damages, any questions of inhuman and degrading treatment. But there does have to be, if there are going to be a number of different breaches of constitutional rights, there has to be some consideration effectively. And really, you have to take a step back and say, is this right in all the circumstances of the case? Now, the trial judge did, we say with respect to him, did absolutely none of that, because he just took a daily rate and he times it by the number of days that he'd found that they'd been detained unlawfully. It is conceivable that the court could conclude, even if your lordships were to say that there was more of a, or there were additional breaches of their constitutional rights than the Court of Appeal found, it is conceivable that the court, looking at it again, could consider that actually their assessment of damages was quite right in all the circumstances, because there were so many factors that the Court of Appeal were taking into account, but there were other factors as well that were being taken into account. So with reluctance, then we would say that the only proper thing that your lordships could do would be to remit the matter to the High Court for consideration of the overall determination of what damages should follow from any findings that you were to make about breach of their rights.
Can I just check, am I right in thinking that the Court of Appeal's award of damages is basically for a period beginning 12 years after the detention?
Yes, it is. And it is, I mean, I would...
It might not be said that's a bit problematic in itself, that starting point, because that overlooks, it may be said, the fact that there should have been reviews actively down to that point in time to see whether either of the defendants were facing trial.
If your lordships were to find that their detention was unlawful from any point earlier than 12 years after they were originally detained, then the underlying basis of the awards of damages that were made by the Court of Appeal couldn't stand. That I would accept. But that doesn't mean that the final analysis would necessarily end up being different. Of course it probably would be, but if one is looking at it on the basis that this isn't just a mathematical question, particularly in periods of very long detention, you don't just do X times Y equals Z, that if you're actually taking into account, when I say you, I'm not meaning you, if one is taking into account the factors that actually are relevant to the assessment of damages, and the principles in CPSAD and Takatoka and all the others that are set out in the bundle, then it is not inconceivable that someone doing the proper assessment could reach the conclusion that 500,000 and 250,000 is nonetheless appropriate in all the circumstances. But that is, with sorry respect, that's not a matter for your lordships. This is essentially a local question, at least in the first instance, that needs to be determined locally rather than here. Because once you, even if you were to say that the declarations that were made by the trial judge in respect of the breach of their rights, even if you were to say that all of those should be reinstated, then the award of damages that the trial judge made absolutely can't stand for the reasons that the Court of Appeal said. I mean, it's the boldest and barest, it's not even any attempt at analysis. All it is a mathematical exercise saying, well, this seems to be the appropriate daily rate. So that one can't, even if all of the declarations are reinstated, one can't reinstate the award for damages properly. There does have to be a more careful analysis, and that is something that we say ought to be done locally.
And you say questions of further evidence.
Sorry.
You say questions of further evidence should also be left.
But also
be left to the local court.
Yes. Yeah. It's got a purely local flavour, and the value judgments about the conditions and so on are appropriate for those judges to be taking, at least as we say in the first instance. One very much hopes that it wouldn't end up troubling your lordships again. But it's not something, we already know that the approach that the trial judge did was blind to the guidance that the board has given on numerous other occasions as to how these damages should be approached. So one can't go back to that. And it wouldn't be, we say, an appropriate exercise for you to be attempting to work out, well, looked at in the round, what's the right figure for these men? If you can't go back to what the trial judge said, and you say you simply can't, then it's not a question of, well, can you properly assess the damages? We'd say you can't. The only other thing, since I do have a short amount of time, and where the issue of the inhuman treatment, inhuman and degrading treatment, contrary to Article 5, I can't remember, we made the point where you don't need that. It may be, of course, that all that one needs, to the extent that that were found, is declaration rather than damages. But that is a heavy conclusion. It's a heavy declaration to make that there's been inhuman and degrading treatment.
So just on that, wouldn't one expect it to affect the level of damages? I mean, it's one thing to be deprived of your liberty generally. It might be said it's another thing to be deprived of your liberty in circumstances where that deprivation amounts to inhuman and degrading treatment, and that should affect the...
It might very well have a bearing on that. I mean, obviously, the question of the damages and the extent to which there's an overlap and which one gets weighted more favourably, and think, yes, I mean, it comes back to it's not a matter we say for the board. But
just on that, in fact, the reason I was asking the question is, how did the judge deal with it? Did he just wrap everything up in his damages assessment? So
did he?
Yeah, did he? So, in effect, was his damages assessment on the footing that not only was there loss of liberty, but also that was in circumstances amounting to inhuman and degrading treatment?
335, paragraph 63. That's the totality of it.
Well, 62 suggests that he simply assessed damages on the liberty basis, which is also what points 5 and 6 of paragraph 64 suggest.
Yeah, I mean, the damages
rather
are...
favourably to the Attorney General. He didn't award any extra damages for his declaration of inhuman and degrading treatment.
It may well be that when he was making an award of damages for over $5 million that he figured that was enough, but obviously there was no attempt to explain that. And of course it may well be that any subsequent judge looking into it would reach the conclusion that some element is appropriate or some element is not appropriate if there's inhuman degrading treatment. So that's why it does matter.
Right. I was just asking for your assistance on what you say the judge's approach was. So if I take it that you're accepting from Lord Leggett that if one looks at 62, 63, and then 64, the formulations in sub 5 and 6, that the judge, in effect, just treated it as a case where...
It would appear so, but there's no attempt to explain that what I'm doing is I'm giving you damages for breach of liberty, even though I'm making a declaration of inhuman treatment, nonetheless, for these reasons, I'm not inclined to award damages for that. So there isn't any thought process any clearer than that. It may well be that what he was thinking was, well, deprivation of liberty, that covers everything. But given that the declaration that the appellants are seeking to reinstate is for inhuman degrading treatment, then it is something that, if this is going to be remitted, it is going to be something that whoever looks at it again would need to consider. And the difficulty we say on that is that in every case, there is a general threshold of minimum severity where the conditions of detention are what are relied on. There's always a threshold. JM at 872, Vintner, which is a case that was put in the authorities bundle this morning, where there's a grossly disproportionate sentence. It needs a baseline of what's proportionate. Strasmeri, the appropriateness of the conditions. Thomas and Hilaire has to be beyond the harsh. This is, in every single case, there needs to be a baseline which has been crossed, a threshold which has been crossed in order to say inhuman treatment. And there is no authority that being in a prison rather than a mental hospital is sufficient without any analysis of the conditions to amount to inhuman and degrading treatment. The extent of the trial judge's analysis of the inhuman treatment effectively comes at page 334, just before where we were looking at paragraph 58. Prisons are not designed as facilities for the mentally ill. Throughout the Commonwealth Caribbean, many mentally ill persons who cannot access psychiatric treatment are simply swept to the criminal justice system after they commit a crime, very often when they've not been adjudged as having committed any crime. There are conscientious and committed consulting psychiatrists. Prison mental health services are woefully inadequate, understaffed and limited. If prisoners without mental illness struggle to keep mental and emotional equilibrium in prison, it must be next to impossible for those with mental disorders to cope in a prison. That might all be uncontentious as a general statement, but it's not evidence. And one has to have all of the Strasbourg authorities emphasising the need to be looking at the conditions rather than just saying location A good, location B bad. And there is absolutely none of that in this case that my submission would entitle a finding that all that we have got, which is prison rather than mental hospital, is inhuman and degrading. That would have very, very far-reaching implications. Even in JM, which was the Prada Willy boy, even then, it wasn't the place that was the inhuman side of it. It was the appalling sexual abuse and the beating and the seclusion and the fact that he was in, effectively, correctional facilities for a child. And here we've got the trial judge saying there's no reliable evidence from the appellants at 333, and the baldest of conclusions about what makes any prison inappropriate rather than what made it inappropriate for these appellants. So we would say even if one is looking at much of what the trial judge said about deprivation of liberty and so on as, well, more inclined to be reinstating days, there really isn't a proper basis on which his conclusion that they had been subjected to inhuman and degrading treatment could be upheld.
But you haven't... I mean, this is just hopeless. You haven't begun to take us to the analysis of Article 3 in relation to prison conditions, for example, in any of the leading cases. Ramirez, for example, where the factors include matters that might be relevant in a case like this. It isn't. I mean, I don't know how many times I've said this, but it isn't just a matter of location. Here, for example, we're talking about 24 years in the case of Noel, and one of the factors from memory is the length of the relevant treatment in prison. The psychological effects on the prisoner are also a relevant factor. Now, we don't have evidence about that I've seen, but one doesn't need a great deal of imagination to have some insight into the effects of 24 years detention without trial. But the way this has been presented to us is utterly hopeless. Hopeless. No authority referred to.
If we're looking at something other than just the name, it says prison, it should be mental hospital, then we have to... You're making the point effectively for me, my lord, that about the regime. And we know nothing about the regime in Bordelais compared to the regime that would have been applying in the mental hospital. We know that it was the same psychiatrist that would have treated them in both, but there has to be something to be saying, this is what it is about where we ended up detaining you that is so offensive, other than just the fact that it was called a prison. And we can't get into questions about, well, it's the regime and it's the effect on the prisoners and so on without any evidence of that. And there isn't any. I'm at the end of my speaking time. Those are my submissions.
My Lord, with your permission, Mr. Logan has asked me to reply.
Yes. Give me just a moment. Yeah, I'm just looking at Ramirez, where it says, I'm looking at paragraph 119. Article 3 requires the state to ensure that prisoners are detained in conditions that are compatible with respect for their human dignity, that the manner and method of execution of a measure do not subject them to distress or hardship of an intensity exceeding the unavoidable level of suffering inherent in detention, and that their health and well-being are adequately secured. The court would add that the measures taken must also be necessary to obtain the legitimate aim pursued. Well, further, account has to be taken of the cumulative effects of the conditions of detention. Well, we just haven't begun to analyse how that might apply to the present case. Yes, Mr. Strang.
My Lord, just starting on that point, in the cases that we referred to earlier, for example, the Winter case, where the inhumanity was a life sentence without parole, the inhumanity in those sentences was, as my Lord Reed pointed out, the lack of penological ground for detention and the lack of hope of release. And the short point to make about that is that the criticism that there's no evidence of a minimum degree of severity doesn't apply to a case like that. It's not about the severity of treatment once one is in prison. It's about the effect of the sentence on the person. And a similar effect is what the judge found in the appellant's case here, or as he characterized it, criminalization of the mentally ill. But it incorporated within that are a lack of penological ground for the detention, and in this case, no hope of release with no periodic review. The lack of periodic review, effectively, we say, indicates that the state wasn't interested in whether the appellants would ever become fit to stand trial. So that's the short point on inhuman degrading treatment that I would make. Dealing with a couple of other short points, just a small factual correction, because my learned friend says that both appellants spent the large majority of their detention in the medical unit. That's not so. Certainly, that's not the evidence for Mr. Knoll. That can be seen at pages 254 and 255, where a chronology is set out. You can see a chronology. The alternative place to see the whole chronology is actually in the parties' agreed chronology, which is page 558. But looking at the evidence, so that's 558 for the parties' agreed chronology. But looking at the evidence, we can see page 254, paragraph 4, as was pointed out, at the time of trial, Mr. Knoll was housed in the maximum security unit. What we see at paragraph 5 is he was initially, when he was admitted, he was initially housed in the medical unit upon admission to the facility in 2003. I understand that was when the facility was first established within the prison. So there's no opportunity for being housed in a medical unit before that date. And then we see that's 2003, but over the page, paragraph 8, he then housed in a different unit from 2006 to 2007, the Foxtrot unit, and he briefly returns to the medical unit before being moved to the Alpha unit in March 2007. And then medical unit in May 2017, that's the end of paragraph 9, and then we know that at the time of trial, he was in the maximum security unit. So the chronology suggests that he didn't spend most of his time in the medical unit. We don't have the same evidence in respect of Mr. Henry. There's not a chronology of his movement through the prison in the same way. My learned friend did refer you to the report of Mr. Guard, which is page 23, the behavioural assessment. That does seem to suggest that by and large he was in the medical unit, but it doesn't provide a comprehensive account of the whole period of his detention. So that's just to...
And sorry, what was the reference to?
That's page 23. That's Mr. Gard's behavioural assessment. Just a couple more points. First of all, the state's reliance on the fact that the mental hospital in St. Lucia wasn't secure enough to house mentally ill people who had not been convicted of a crime, but who were potentially dangerous. In my submission, that's reliance on the state's own failure to provide a secure facility. And it can't turn the requirement in Section 31 to house the appellants in a mental hospital into a discretion to imprison them. In a sense, that's like the case of CPC, where the magistrate where there was no appropriate facility for the child defendants. The magistrate had no option but to send them to an adult facility. The magistrate had no option but to break the law, was the finding of the board. And as for the interrelationship of the code and the Act, just would point out to your lordships that the Court of Appeal did have the 1889 code brought to their attention. That's page 421. The chronology of the code was set out, and it does include the 1889 code, because these were the state submissions below. And the 1889 code was brought to the Court of Appeal's attention at paragraph 9 there. The 1889 code is, sorry, 1888 code.
It's 88 rather.
Yes, 1888 code, sorry, is in the supplemental bundle, or at least section 209 is.
And sorry, you did tell us, but what is this document?
These are the appellant submissions, the state's submissions below to the Court of Appeal.
Sorry, the state's.
The state submissions to the Court of Appeal. Yeah, they start at 419. You can see there it's the Attorney General, the appellant. So just taking a look at the 1888 code in the supplement, it's in the first supplemental bundle. We only have section 209, which is the predecessor to section 1021 of the current code.
Which page?
It's page 4 of the first supplemental bundle. And so this was what was enacted before the Mental Hospitals Act. And it's in materially the same terms as the present section 1021(1) and 2. And
So
the point I make.
This is what was in. I mean, as you say, it's almost the same as the
Yes.
current code. So this is what was in force when the Mental Hospitals Act was enacted.
Yes. Yes. So this is effectively in place before the mental health provisions have been comprehensively enacted. And the first point I make about that is it's in terms that is in, if I may use the phrase, statute blind, in that, for example, section 2092 requires the governor to deal with the laws of this colony for the time being in force. So there's an expectation that decisions under Section 209, or under this provision, are going to be guided by mental health legislation, and I say that expectation governs subsection 1 just as much as it governs subsection 2. And it would be no surprise in my submission to find, once a comprehensive mental health provision is enacted, to find the discretion under section 2091 narrowed by the specific requirements of the statutory scheme for mental health and for the care and custody and treatment of the mentally ill.
And did that occur in 1895?
It occurs in 1895 with the enactment of the Mental Hospitals Act. And I say this is the first comprehensive mental health legislation in St. Lucia because we don't see a repeal, or we don't see a repeal provision in the Mental Hospitals Act. There was in the laws of St. Lucia that we have seen, from which we took the 1888 code, there was a brief provision for the confinement of mentally ill people, similar to what you find at Section 6 and 7 of the Mental Hospitals Act, but nothing about unfitness to plead. So, as I say, no surprise in my submission to find the discretion in the code narrowed by the comprehensive specialist provisions for mental health and the care and treatment of mentally ill people. If the result is that the discretion is narrowed to mental hospitals, it may be not much of a discretion, I accept that, but the Court of Appeal and the Respondent's alternative is that the Mental Hospitals Act itself is repealed, Section 31 was repealed by the subsequent reenactment of the code. In my submission, that's a much less palatable option, and it's not required by the interrelationship between the acts or the words of the acts.
And just on the ambit of the discretion, I mean, it might be said one should read Section 31 of the Mental Hospitals Act with Section 30, which allows the governor to designate effectively anywhere as a hospital. So,
yes.
In theory, the governor could have designated 30 very different places, and then clearly there would be something for the discretion to bite.
And indeed, if more secure facilities were required, that's an answer to the state's point.
Yeah, and also, I mean, since he can designate a house or other place, I mean, dealing with these, the point about dementia and so on, that the person's not a threat to anyone, but they need to be put someone to be looked after themselves.
Yes.
A house, with suitable care staff could be designated for that as a prison, just for the purposes of the operation of this part of the.
Indeed, it could be, yes, my lord, yes. And of course, the Mental Hospitals Act itself provides for more than one kind of mental health facility. A mental hospital is one of them, and that would be the first stop under Section 31.1. Of course, the Governor General's discretion under Section 31.1 would encompass all the possible mental health facilities designated by the state. Mm-hmm. That's a slightly different point, I
accept. The other change is that whereas the original criminal legislation and indeed the current code simply envisages a verdict by the jury on the question of sanity, and then the person is dealt with under mental health legislation. The Mental Hospitals Act, Section 31, introduces the idea that there might be a subsequent trial. The order is to be that the trial be postponed until the person becomes of sound mind. I don't know if that's probably modelled on English legislation. It's not something I've come across myself before.
I'm not sure, my lord, but I suppose that the code itself, the code also, certainly in its current form, that's a point about the difference between the old form of the code and the current, because the current envisages, the current says that the finding under Section 1019 won't affect the future trial should the person become of sound mind.
Yeah.
Well, I think those are all the points I had in reply. So, unless there are any further questions, I have no further suggestions.
Well, no, thank you very much, Mr. Strang. Well, we'll consider these submissions and let you have our decision in due course.